Court of Appeals for the State of Michigan is now in session. The Honorable Christopher M. Murray, the Honorable Allie Greenleaf Maldonado, presiding Honorable Daniel S. Crawford. All persons having business in hearing draw near, the petition and shall be heard. God save the United States, the state of Michigan, the Honorable Court, please be seated.
Well, good morning. Welcome to the Michigan Court of Appeals. This is the second day of case call for panel 5 of the court's December 2025 session. My name is Dan Korotkin. I'm here today with Judges Christopher Murray and Allie Maldonado. We're looking forward to your arguments. We understand that these cases are important to the litigants and to counsel. We want to assure you they're important to us as well. We've been diligently working on these matters. We have the benefit of your briefs, our excellent research division, our own chamber staff, and of course, we ourselves are familiar with the cases. We're going to ask you to focus your oral argument on your most important points, why you should prevail, and what's critical for us to understand. Finally, to the extent that we are hearing matters today involving sexual assault victims, personal protection orders, and or children, because these proceedings are recorded, we're going to ask that you please use initials when referring to any victim or child or vulnerable individual in those cases. With that, we look forward to hearing your arguments, and we will start by calling item number 1. Which is, was item number 17, because we're continuing from yesterday. And that's O'Neill DePriest Swanson versus Ben J. Parker, docket number 373617. And I believe we don't have argument preserved for the appellant. So we just have someone here from the appellee.
Good morning, Your Honors. Neil Giovannetti on behalf of defendant appellees Benjamin Parker and Marshall Ogden. As the court's aware, the appellant did not file a reply brief or preserve oral argument. Accordingly, appellees have had the last word in their brief, which explains why the circuit court properly granted summary disposition in this case. So unless the court has questions, I'm happy to rest on my brief.
I thought your brief was very good. I have no questions.
No questions.
No questions from me either, so thank you very much.
Thank you.
Okay. Thanks very much. We have the next case up is item number 18, docket number 374608, Wanda Hicks versus Herman Ruiz. Now, plaintiffs have not preserved oral argument, but we issued an order in this case allowing you to appear in case we had any questions. Mr. Bell, I assume that's you. Would you like to come up and place your appearance on the record?
Good morning, Your Honors. Cameron Bell on behalf of the plaintiff, Wanda Hicks.
So, Mr. Bell, I do have a question, which is the issue I'm trying to think through is the standard of review, which is for experts abuse of discretion, but for summary disposition is de novo. And I think the appellees have noted that there's no statute prohibiting the trial judge from considering how long it's been since the expert has engaged in this particular procedure.
Right.
And there's also no statute, saying it the other way. So I guess understanding your overall argument, do you have any thoughts on how we ought to deal with the standard of review in this case?
Well, Your Honor, I think I can give an example that it will properly convey what I want to say. Essentially, I just had a deposition yesterday on a medical malpractice case where my expert had not performed a particular procedure for quite some time. However, he was still able to testify to that procedure and the aspects as to what happens with that procedure, as well as post-operative care. So I believe that situation to kind of be applicable here when it comes to the standard of review. the court obviously has a broad discretion when it comes to determining whether an expert is able to speak to certain issues pertaining to a particular case. Here, just because Dr. Matthew did not have an opportunity to perform any of those procedures within the past 10 years does not mean that he loses knowledge about it. You can use an example as far as a traffic ticket. Traffic tickets, things change as far as over time. However, if somebody stops practicing criminal law and decides to go a civil route or a different route, that doesn't mean that they forget how to do that particular aspect of their job. And I believe that to be applicable here as far as the facts in this case. Dr. Matthews, it was a lower kind of procedure as far as complexity that he was no longer doing. However, I'm sure he had fellows and other residents in which he instructed how to do these procedures. So to me, that shows a basis of knowledge, and that shows that he has the requisite knowledge in order to be able to testify and represent as an expert on the case. I don't know if that answers your question, but that's.
Yeah, no, thank you. Appreciate that. And, that's what's been on my mind. So I appreciate your being here. Any other questions from the panel? Okay. Thank you, Mr. Bell.
Thank you.
Good morning. I'm Adam Pradko on behalf of defendants. So I guess I'll just jump right in. It seems like the panel is very prepared. On the issue of the standard of review, I think, it's just important to note that we have two different rulings here that are at issue for the court. There's the discretionary ruling with the qualification of the experts, and then there's the ruling on the motion for summary disposition, which is reviewed de novo. So I think, in terms of the discretionary ruling, I think in their brief on appeal, appellants really focused in on this issue of how, the court had indicated that Dr. Matthew hadn't performed the procedure in about 10 years. But really, there were two sides to the court's ruling. The first was that there was no medical literature supporting that he was using to rely on to support his opinions. And the second
But he's
issue.
not required to have any kind of articles or medical literature. I mean, you can, but didn't that just go up to the Supreme Court not that long ago? And they're like, yeah, you don't actually have to.
Yeah, it was last summer. I believe it was Danhoff. Yes, the Danhoff case. So you don't need literature, but that is the preferred way to support your opinions. The court also said that you can use some other form of support, and then kind of the lowest tier is just education and experience.
So can you just remind me, was this judge's opinion before that went up to the Supreme Court?
It was after. I think this was a February 25 opinion by the trial court.
And you don't have any literature, right, suggesting the opposite?
We were able to find a couple articles. The court, we'd filed our motion for summary disposition, and then the court asked for supplemental briefing on the issue of the expert qualification. At that time, we did find a couple articles. One other point I think that is relevant now is that,
what were those? I mean, were those articles contradicting what the expert was saying about? Well, let me back up, because, of course, one of the interesting things about this case was that it started off kind of big,
right,
and then and now it's really just about, as I understand it, the Dr. Ruiz's response to the plaintiff's complaints of pain. There's a dispute about how well the patient articulated her symptoms at the time. I think she says she described it as horrible, severe pain. Dr. Ruiz said no, she didn't say that. Okay, but when it comes to literature, I mean, are you really contesting that a doctor should respond promptly to a patient's complaints of pain?
Well, I think, kind of the heart of the trial court's ruling was that, we know that pain can happen after this procedure, but what Dr. Matthew didn't say was what's the threshold between a normal amount of pain and way too much, that they should know something is wrong. And, another thing is that we don't even know if the severe pain is diagnostic of a hematoma. We did find literature, and as you're saying, the case started very broad, where basically they were blaming Dr. Ruiz for everything. And then while our motion for summary disposition was pending, they dropped everything except this few hours here. And so we don't know from his testimony, we don't know from the literature that we found that these symptoms are going to start immediately. We don't know that severe pain is diagnostic. Plaintiff got to the hospital a few hours after the injection, and it was another 4 or 5 hours before they even diagnosed the hematoma. So, I think if it was so obvious that this was a hematoma they were dealing with, one would expect the emergency room would have figured it out very quickly.
But in terms of literature, I guess you don't have any literature, I take it, that says even when a patient complains of severe, horrible pain and pain radiating down their arm after one of these procedures, that's normal. It's nothing to worry about.
Our literature does not say that, no. It's very scant on.
So that I think is a little different from some of the Supreme Court cases about literature, which is when the court is trying to figure out, okay, we've got literature on one side and an expert on the other who's contradicting the literature but has nothing to back them up. The court should consider the literature as being quite influential in whether the expert is reliable. But here it seems that we have, again, I mean, the case started very big and there's a lot of dispute about, standard of care around the actual procedure. But now it seems like we just have a case about the patient complains of severe, horrible pain. That's what she says. Dr. Ruiz doesn't say that. And the question is whether if Dr. Ruiz heard that testimony, heard those complaints and did not take urgent action, whether that reached the standard of care, right? And so I guess the literature point just seems, I'm struggling to figure out why the literature point is important.
Yeah, I think, really this isn't your typical battle of the literature case. We see a medical malpractice where they have their articles and we have ours and we're seeking to disqualify and, it's sort of, well, where's the truth? There's a lie in the middle. This is a case where it's their expert whose qualifications were at issue. We don't have to prove that their expert should be disqualified. The burden is on them to prove that their expert is qualified.
The table was like nothing.
I'm sorry?
The expert came to the table with nothing. Hadn't done the procedure in 10 years, no literature, no real experience with it, didn't do any research on his own, nothing.
Right.
And the judge, as a gatekeeper, said, not good enough.
I think
Right?
one of the articles we did cite, it was something, this one particular clinic had 2 hematomas and 23,552 of these procedures. So this isn't a situation where the doctors are used to seeing it. There's nothing to say that there isn't this severe pain that happens 1 out of 100 times as opposed to 1 out of 12,000. And I think to kind of get back to the point, it's their job to prove the qualification of the expert. And the trial court basically said, as Judge Murray was saying, you don't have enough here. I don't think that the hasn't done the procedure in 10 years is necessarily completely dispositive on this issue because, as the court said, if you'd had literature, it would have been fine. And there is some out there. I think, I believe it was Danhoff, the Supreme Court was saying, you don't have to have the literature, but basically where not having literature is not that big of a deal is when we're dealing with a topic that has no literature. If these things are so rare that they just haven't come up in literature. And this is a rare condition, but it's prominent enough that there's at least a few articles out there.
Are you familiar with, I don't know if you came across the case of Albro versus Dayer?
Yes.
Dreyer, I'm sorry, Albro versus Dreyer.
I don't remember if
This was a case where the experts also had either not done the procedure or hadn't done it in a very long time. Um, and, um, and that was, the Court of Appeals says that's, that goes to weight, not
Mhm.
credibility, or weight, not admissibility. If
Right.
you
Well, I
had
believe in
any-
that case, either one or both of the experts who hadn't done the procedure had written journal articles on the topic. So it wasn't as if, they're completely unfamiliar with it. I think the issue was they performed the procedure in one manner, and there's a few different ways you could do it, and the defendant in that case used a different one. So it's a little different issue than this case where there's nothing in the deposition of the expert that he is really familiar with these things at all. He said he used to do them, but it's been a long time.
I think the quote is, "I'm very familiar with them." That's what he
I-
said.
I
I mean,
trust you
is
if you
this a
say so,
procedure
Nick.
that has changed? I mean, it could have if it's been 10 years. Has there been a significant change in how this procedure is done? Do you know?
Not to my
Or is that in the
knowledge. I
record?
think, the appellants in their briefs say, well, there's continuing education and, these things get updated. And I think our point would be that if these things are being updated, then there should be literature on it. And if there's not, if there is literature saying this is how we're doing it now, then, why didn't he come to the table with it?
I mean, to me, that was actually going more to the point that if there had been an update, that's more in your favor.
Oh,
But
okay.
but if there's no update, then I don't see why it matters that he hasn't done it in 10 years. That's what I was trying to suss. I couldn't remember from everything I read, whether or not that was the case. So thank you.
It's
Else?
there.
I
Okay,
don't think we have any other questions, so thank you very much.
great. Thank you.
Okay. That case will be submitted.
Yeah, I found that case. Take a look.
The next case we're calling is item number 19, Huntington National Bank versus Kevin John Riemann, docket number 373686. Council, we did receive last night a last minute motion from council to withdraw his appearance and allow the in pro per appellant to argue. We're inclined to grant that motion unless there's any objection from counsel for appellee.
I leave it to this court's discretion.
Thank you very much. Mr. Dunn, is that you?
I'm actually appellant Kevin Riemann.
I'm sorry.
Yeah.
Mr. Dunn is your now former attorney.
Yes.
Mr. Riemann, welcome. Please approach and whenever you're ready.
Thank you, Your Honor. If it please the court, Your Honor, it's Kevin Riemann, appellant in this matter, in pro per. Judges,
Next time, try to file a motion a little bit sooner,
yes,
2 weeks before oral argument.
yes, I appreciate that and understand that, Your Honor. I appreciate your consideration to hear me. Mr. Dunn and I had thought because I was listed pro se.
I read the motion,
Okay.
I'm just saying,
So, yeah.
maybe look at it more than the night before.
Yes, I appreciate that. Judges, this case went sideways right from the very start. And if this doesn't get your attention, I don't think I'm going to have any luck here. But at the very first hearing, just 6 weeks after the complaint had been filed, some 6 years after the bank alleges a default, the judge wouldn't allow me to speak, said that I was defaulted, and ordered that the property that I owned be sold and the mortgage paid off. So we sorted through that, and the judge eventually looked at the file and noted that I was not defaulted, that I had timely filed an answer and a counterclaim and an objection to the motion for appointment of receivership, and I was allowed to speak. But she still entered an order at the very first hearing and without any evidence that this loan that's the subject of this case was properly owned by Huntington Bank. She ordered that they have a receivership and that they be permitted to sell the building and pay off the mortgage. That's really the end of the case, and that was at the first hearing. The Huntington Bank did not offer an affidavit saying how they took ownership. They did not offer a witness saying how they took an ownership to the building. They simply alleged it in a pleading. And the judge granted the power of sale. And that continued for the next 2 or 3 years as they attempted to sell the building several times and eventually did sell the building for about $20,000 more than the principal on the loan at the time of the alleged breach. So that's just the very start of this case. This case is really about the evidence at trial. And at the trial, there were 2 witnesses. The first witness was offered by Huntington National Bank. It was a mid-level loan manager who testified. She had never heard of this loan until 6 months after this case was filed, which would have been July of 2023. They alleged the breach occurred in February of 2018, over 6.5 years before she ever heard of this loan. And she testified that she only became involved because she was the manager of a Huntington National Bank employee who was assigned to this litigation case. So she did not know about this prior to the case being filed. She testified honestly that the question about whether or not the Huntington National Bank took ownership of the loan at issue was, and this is her words, quote, above my pay grade. I asked her pointedly, can you tell this court, do you know whether your bank, the Huntington National Bank, took ownership of the loan at issue from Chemical Bank through a double merger? And she testified very clearly and honestly, no, I cannot say that. I don't have access to that information. Now, Mr. Nair attempted to rehabilitate her. At the very last question he asked her was, is there any evidence that the loan for Riemann was sold to Horizon Bank? And she said there was no evidence. Now, that was very general, but he was referring to her earlier testimony that she did realize that during the merger from, so we got 2 mergers here, Chemical Bank to TCF, then TCF to Huntington. And Ms. Johnson testified earlier that in the merger from Chemical to TCF, she was aware that not all of the branches were transferred and not all of the loans were transferred because some of the loans were sold to a company called Horizon Bank. And then her testimony established later through press releases that she acknowledged on the merger from TCF to Huntington Bank that not all of the branches and loans were acquired that TCF had by Huntington. So I just asked her straight up, do you know, have you seen, can you testify that the loan that I signed for in 2013 for Chemical Bank was acquired by TCF and then acquired by Huntington? And she honestly said, no, I can't say that. She never took back that testimony. That's their sole evidence that they have a right to ruin my life financially. They've taken my building. They sold it for $290,000 on a $265 alleged default, and they're still alleging that I owe them several hundred thousands of dollars. And that's their evidence. Now, it may be that Mr. Nair didn't seem to need to bother because he'd already got an order from the court in summary fashion to take my building and sell it, which they did. So maybe they didn't bother, I don't know. But the other evidence at trial, let me give you the rest of the evidence. It was from Matt Reyes, my former partner. We had a falling out, a terrible divorce of our law practice that resulted in him locking me out of that building in, according to the testimony, October of 2015, when this mortgage was paid up full. I'd been paying on the mortgage for some 30 years with different partners, over $1 million. And the testimony is, after that time, the note was paid up until February of 2018, when it became due for a balloon. It was a 5-year rotating balloon. And the evidence at that time is that Mr. Reyes had some dealings and negotiations with Chemical Bank that he never heard from TCF. He testified they didn't take over the chemical branch, and the evidence was this branch was only 50 feet from the law practice where this building was. So it's right next door. And he said he never heard of TCF. There was nobody from TCF who said they took over for chemical. There was no change of signage. The only evidence is the branch closed as a chemical bank and opened up as a restaurant, which is consistent with the position that I've taken, and that is that this was a non-conforming, non-performing loan that was not acquired by TCF. Nobody bothered to value this loan as worth anything more than the collateral. And so it just went away.
I thought in a merger, if one company merges into another, that company, the remaining company,
Yes,
under the law, generally assumes all of those.
absolutely, Your Honor. And that is true. And there's a statute that says that.
All right, so then why wouldn't that simply someone provide the answer to this?
Yeah, because the answer is that is the rule unless there is evidence that not all of the assets were acquired in the merger. And in this case, we have affirmative evidence that Joan Johnson testified. I presented her with a couple of documents and said, don't you recall? And she said, yes, that is true. Not all of the assets of chemical were acquired by TCF, and not all of the assets of
She's the one
TCF.
that said it was beyond her pay grade,
Yes.
and she testified about what assets were part of the merger. Sounds like it's, I mean, isn't that above her pay? I mean,
Well, yeah, she said she knows that not everything was acquired, not all the branches and not all the loans, but she can't say whether this one was acquired. So we've gotten beyond the presumption that all of the assets were acquired. In fact, but Judge, that's an interesting point, because when the plaintiff presented their case, they didn't tell the court that. They presented this case as a merger from chemical to TCF, from TCF to Huntington. It wasn't until cross-examination where I asked and presented Ms. Johnson with some documents, press releases, et cetera, that she acknowledged that that was true. Not all the branches were acquired in either merger, and not all the loans were acquired in either merger. But even beyond that, Your Honor, we came to a point where there was motions where I was arguing they have to prove this merger. The merger didn't include our loan. There's no evidence it ever did. Throughout this whole case, no evidence. And counsel.
So was your loan like paid and got lost in the shuffle, or what happened?
Yes, Your Honor, what happened is it was a 5-year rotating balloon. So as new partners, my last partner became a circuit judge in Bay County, and then the other one retired to Jamaica. We brought in a new partner. We signed a new loan document in 2018. I'm sorry, 2008. So it had been rotating every 5 years to that point. In 2013, we signed it again, renewed it. In 2018, we had split, the partnership had split, and that's where it kind of fell through the grates, because there was also evidence in 2018, and I presented this, that in February of 2018, it's in evidence, the letter I received from the first vice president of Chemical Bank, who we dealt with, saying, hey, Kevin, your loan is due. If you don't present us with the materials we need to renew it, within 30 days, we're going to proceed with foreclosure. Mr. Debo didn't testify, and the Huntington Bank offered no evidence whether or not the loan was renewed. In fact, Ms. Johnson testified, they have the system, the computer system from Chemical, but it only goes up to when Chemical was acquired by TCF. And so they don't have anything after that loan became due in February of 2018. Now, there was some testimony from my former partner, Mr. Reyes, who was also a defendant. He testified that he did not receive any information from TCF. They never claimed the loan. But Huntington did about 2 years after the alleged breach in February of 2018. He said he got a letter from an attorney who said he represented Huntington and that the loan was in default. Mr. Reyes testified that he contacted the lawyer, worked out an arrangement to resume the monthly payments. I think he said $2,000 monthly payments, and he attempted to make the payment, and that he was contacted by whoever received his payment at Huntington Bank, and they said, hey, we don't have anything to apply this to. Stop making payments. And that's the only testimony that was not rebutted by Huntington Bank. Matt Reyes said he tried to pay Huntington. They said they had no loan document to apply it to. And that was the end of the proofs on it. Mr. Reyes, yeah, I think that's the extent of his testimony on that. Now, this is not somebody who is trying to help me. We have a terrible, terrible relationship. And in fact, Matt Reyes let this case be defaulted against him and our holding company who he represented. So not only has Huntington achieved selling my building, keeping all the proceeds of the sale, they also appointed a receiver of their choosing, and that receiver appointed a company that they owned to sell the building. So they took a cut, and the receiver tried to sell the building initially when the judge ordered it be sold for $230,000, although the receiver themselves had appraised it at $340,000. So I objected long enough and showed the court that this wasn't a real buyer. The buyer didn't even have a registered office as required under law, and miraculously that sale fell through. And within weeks, another buyer stepped in and paid $60,000 more. $289,000, which is what they sold the building for. Again, this reverts back to a note that supposedly defaulted in 2018, 5.5 years before they filed suit at $265,000. So from a fairness standpoint, they've done very well in this case. It's just whether or not, given all of this and no notice to me for almost 6 years after the alleged breach.
Well, it's still timely, so it doesn't.
It was timely, but from a fairness standpoint, Your Honor, they told me in writing that if this is not renewed, you will be foreclosed within 30 days. And I submitted that. That's the only contact I had with them. And I did believe, reasonably based on that Mr. Reyes, and what I was told, that Mr. Reyes continued that loan. I had full rental of that building. I was managing it until I was locked out in 2015. Mr. Reyes changed the resident agent to himself he took over the holding company. The renters continued to pay rent to Mr. Reyes. Mr. Reyes did not continue to pay the bank. As it turned out, the bank knew this. They had full authority to come in and take the rents. They filed a document in court in 2019 that says we can now come in and take the rent. But they didn't. And they didn't file suit. They didn't contact me. They tried to claim they didn't know how to contact me until I presented a certified letter that I had received from the bank in 2018 at my current address. This is another interesting point. Judge,
Is this all evidence that was in the trial?
yes.
Okay.
Yes. And what's
Mr.
interesting,
Rubin, I think we understand the main gist of your argument, which is around the testimony at trial and whether Ms. Johnson really could establish through competent evidence that this was Huntington's note. So, I mean, I think we've got it.
that is certainly the main point that
Okay.
I want to express. Yes.
So thank you.
Yep.
We'll give you some time for rebuttal after your opponent comes up here. Okay.
Thank you for your consideration.
Thank you, Your Honors. Henry Nyer, appearing on behalf of Huntington National Bank. The question is this in the record? There's very little of what was said today that's in the record. Mr. Riemann had the opportunity to testify at this trial, and he chose not to testify. And he made lots of arguments, arguing with his former partner, arguing with me, arguing with the court, but he did not testify. And I'd urge you to look closely at the record, because much of what you heard today simply is not part of the record. This case really comes down to the standard for review of this case. MCR 2.613C provides a clearly erroneous standard. Michigan Supreme Court explained that in the Beeson versus Beeson case, 435 Mich 791. If the trial court's findings of fact are plausible, a reviewing court cannot reverse the decision. So it's not whether we think the Judge Clapp's decision was right or not. It's whether we think that her view of the findings, her view of the facts of the case are plausible. And she was, very methodical, did a, very clear job and laid it out very well in her opinion and in order. And earlier in the transcript, when she ruled on the topic of the ownership of the loan, and I think all you gotta do is look at those and, clearly her findings are above and beyond a plausible standard. Frankly, the court has, I wanted to, the comment was made, the question about mergers and acquired by language. Yes, the Kim versus JP Morgan case that Judge Clapp cited it in her opinion. We didn't cite it in our brief, but that walks through and explains that, yeah, when there's a merger, the assets go to the next bank in the merger, and that's not just a banking rule. It's a merger kind of rule. So with that, unless the court has questions, I'm not going to take any more of your time. Any questions?
No.
Thank you
Thank
very
you,
much.
Your Honors.
Thank you very much, Mr. Nair. Mr. Reaman, if there's anything briefly that you'd like to say on rebuttal?
Yes, very briefly, Your Honor. Thank you. Just on that point, and I guess the question is then whether I'm being accurate about what I'm saying with Ms. Johnson's testimony. And it's at page 46 of volume 1 of 2, the excerpt from her testimony on Thursday, May 30th, 2024, where I ask her, is this promissory note included in some sort of merger agreement with TCF? This is chemical to TCF. And she says, on line 10, I can't speak to what's in the actual agreement. Now, this is in conjunction, Your Honors, with her testifying that she knows not all the branches and she knows not all the loans were conveyed in either merger. Then I said, okay, you understand that there are merger agreements. She answers, I do understand. And those merger agreements come about at considerable attorney expense who negotiate what gets included, transferred, and the terms of those transfers. She answers, I would not have access to that. I'm not involved in that. And I asked, okay, you just know that it goes into a merger agreement. And she said, I've never reviewed a merger agreement if that's what you're asking for. And so I said, okay, so you do not know if this particular loan was part of any bundle that was included in any merger agreement from Chemical Bank. First, let's go to TCF. True, you just don't have that information. Answer, I don't have that information. That's at line.
Did she testify that she was assigned to process that loan?
She testified at some point, Your Honor, she was not aware of the loan until 6 months after this suit had
That
filed.
wasn't my question.
Oh,
The question was she aware that she was assigned responsibility for the loan?
I don't know her exact language, but she
That's
said,
what the trial judge said, she said.
okay. She said she was assigned to the case during this lawsuit, or she was assigned to it during the lawsuit. And then again, I asked her one more time, more specifically, whether she knew about the TCF to Huntington Bank, and she says at line 10, I do not review those agreements. Now here's, I'd ask you to bear with me. I think it's even more important than just on its face, her saying she doesn't know. She knows not everything's included. She doesn't know about this one specifically, because counsel admitted to the court, as I was arguing this during one of the motions, he stood up and said, Judge, this is ridiculous. I have the merger agreements right here in court. It's ridiculous, Mr. Reaman is saying that his loan was not included. I have the merger agreements here in court. And I said, okay, well, we'll see then. But counsel didn't admit the merger agreements. He didn't ask anybody to testify to it. And I've cited that in my brief. The reason that's important is under these circumstances, legally, the presumption is that the merger agreement would have been adverse to their position. They did not establish the merger agreement included this loan in any other way. They told the court they have the document right here in court. Now, Mr. Nair denied saying that when I argued it later in that case, but we now have the transcript and it's cited in my brief. He said, Judge, I have it here, and he didn't produce it. So on top of not having any evidence that this specific loan was included in either merger, on top of the evidence that they submitted that not all the loans or branches were included in either merger, they now say they have the merger agreement in court and refuse to submit it into evidence. And that's where the presumption comes in. Not only did they fail to meet their burden, but the presumption is against them. You read the court's order, she said, Mr. Riemann raises that, but I hold that against Mr. Riemann. She doesn't explain why, but it only makes
I think
sense.
you're going beyond.
Okay.
Rebuttal.
I appreciate your time. Thank you, judges.
Thank you, Mr. Riemann. That case would be submitted. Move on to item number 20, Alejo versus Singh, docket number 374558. Morning.
Good morning, Your Honors. For the record, Coleman Potts, P 7607, on behalf of appellant Yarica Alejo. Your Honors, this is our request for this court to reverse the trial court decision granting summary disposition in favor of defendants based on the sudden emergency doctrine. What we have here is a case where appellant was a passenger in a vehicle that was rear-ended by a defendant who was traveling at a high rate of speed. Defendant was driving a truck that was owned by Gigs Express. It is undisputed that the plaintiff lost consciousness. So we are here. So all we have here to refute the defendant's testimony is the prima facie evidence that the plaintiff was a passenger in the car that was rear-ended by defendant.
Well, we also have the video, and that tells it does tell the story of a rear ending, but it also, I think, tells the story of a pretty bizarre and sudden emergency, doesn't it?
I think we have a video, but I don't believe the video is enough to rely on for the court to determine as a matter of law that it was a sudden emergency. What we have is a video. I think, in my opinion, the video is a little grainy, that shows two cars traveling on a highway, and that the car in front of the car that was driven by the defendant came to a stop. But what we have to look at here is whether something was out of the ordinary. What we have here is two cars traveling on the highway. Nothing out of ordinary about that. What we also have is a car on the right side of the defendant's truck, and we have the car that the appellant was in. She was the passenger in the car. There's nothing out of the ordinary about cars traveling next to each other on the highway. I think,
But the video shows, and the defendant testified, that the car was basically stopped in the middle of the expressway, either stopped or idling. And the video does show not only, it's hard to tell whether it was actually stopped or just going much slower than traffic, but it was clearly going, way, way, way slower than expressway traffic. And then there were no brake lights on until the very last second. So you basically had a car without brake lights. The taillights were on, but no brake lights. And there was no stop traffic up ahead. So there was no real indication looking ahead that there was going to be an obstruction in the road. And so of course it's a video, but the defendant testified, look, I was traveling the regular speed, and all of a sudden there was this car in the middle of the expressway that appeared to be either stopped or going extremely slowly. I think that's the record that we're grappling with.
yes, I understand that, but also in this case, I think we need to look at the testimony and also balance that with the evidence, and that evidence being that this was a rear-end collision. And with the rear-end collision, I think that is something that the jury should be able to consider whether the driver of the car that rear-ended the other car had time to stop, had time to apply his brakes, whether he actually saw the vehicle in front of him with his headlights. Yes, we discussed the fact that the video shows that the lights on the car in front of him may not appear until a sudden last moment, or at least that's their argument. But I do believe the jury should be able to consider as whether he actually saw that vehicle in front of him, given the fact that he does have headlights on his truck as well. And I think just the fact that
The fact that he does have what? I'm sorry.
headlights on his car as well. I think the fact that headlights illuminate the highway should be considered by the jury.
Well, what's the factual dispute? I mean,
Well-
that's what summary disposition's for, right? And don't we say whether a reasonable juror would conclude that there's a genuine issue material fact?
Yeah,
Yeah, and I mean, I'm not gonna repeat what Judge Crockett said, but I mean, the video is a video and it encapsulates the entire accident. What are we gonna have a jury look at it for when we looked at it and said, it's a sudden emergency?
And that's essentially our argument. I think because if it was not a rear end collision, we may not be making this argument. However, because it was a rear end collision, I think submitted to a jury, the jury can determine whether or not the driver of the truck had time to stop, had time to apply his brake, had time to do anything else but smash into the back of the car. And that's where we're submitting to the court.
So this is like an issue that I had to do a lot of reading to kind of catch myself up on the sudden emergency doctrine. I'm not that familiar with it. And I was trying to, so that's a judicially created doctrine. That's something that I learned when I was doing my little research here. And then I was trying to like line all these things up together because it also, I was trying to like put it in a picture frame with the Supreme Court's decision that we would now apportion contributory negligence, right? That's also something that's, pretty new on the scene, a couple years old. And so I was looking at this. Can you just help me understand? So then you have this other doctrine that's like, well, if you're rear-ended, there's kind of like an assumption that the person who hits you is negligent. Help me line everything up. Can you
Yeah.
like teach me a little something here
Yeah,
today?
so if we're looking at MCL, I believe it's MCL 257.
0.627.
Yeah, which creates a prima facie case that in a rear end collision, the defendant is prima facie negligent. And then the court created the sudden emergency doctrine to kind of act as a defense to that, which kind of usurps comparative negligence, where if we were to go to trial, the court would then, or the jury would then determine, well, was the driver of the car in front of the truck, were they 50% or more at fault? Because then if they were, then they'd be barred from recovery. Well, here we have what was presented to the court, the sudden emergency doctrine, basically saying to the court that what happened was so out of the ordinary that the defendant did not have time to react. I think just written into the sudden emergency doctrine are so many questions. The fact that it has to be submitted to a jury. Did the defendant have time to react? Did he have time to pump his brakes? Did he actually see the car in front of him? Given the fact that trucks have bright headlights, and even if the car was if he was traveling 2 car lengths behind the vehicle, did he actually have time to stop? I think those are all questions of fact that the jury should be able to consider. I think our case is most like the Petrosky versus Juserman case that we cited in our brief, where the plaintiff in that case was rendered unconscious as well. And at the close of plaintiff proof, the trial court took the driver's testimony that he applied his brakes prior to the collision as evidence that he was free from negligence, and granted a directed verdict. I think just like the plaintiff in Petrosky, plaintiff in the instant case was rendered unconscious, did not remember the accident, but was in a rear end collision pursuant to MCL 257402. Which says the rear end collision prima facie evidence of negligence states in any action in any court of this state when it is shown by competent evidence that a vehicle traveling in a certain direction overtook and struck the rear end of another vehicle proceeding in the same direction or lawfully standing upon a highway within the state, the driver or operator of such first mentioned vehicle shall be deemed prima facie guilty of negligence.
The problem with that case for you, it seems to me, is that there really was a dispute of fact there because the defendant in that case gave inconsistent testimony. I think if right after the accident, he said one thing about his brakes, and then a year and a half later, he said something else about his brakes. And so the Court of Appeals said, look, this is the kind of thing where the jury has to decide which of these stories that the defendant told is the true story. I think we only have one story here, and it is true that we have to look at all the evidence and then try to determine if any reasonable jury could find that defendant was negligent here. But you know, I mean, that's always a judgment call, but assuming we do that, I guess going back to Judge Murray's question, I'm not, if there's an actual factual dispute here, I think we need to hear about it.
Well, I think what's important in this case is we're looking at the testimony of one party because that's all we have, because the plaintiff, of course, testified that she was rendered unconscious, she can't remember everything. But that testimony does not eradicate the fact that this was a rear-ended collision. And I think the simple fact that it was a rear-ended collision, yes, they can claim sudden emergency as the defense at the trial, but I think the fact that it was a rear-ended collision in and of itself should submit this to a jury. I think their reliance on the cases that they cited is a bit misplaced. Because I don't believe this is something that was unusual, unsuspected. I think traveling on a highway, traveling with cars around you, I mean, I could be traveling back to Detroit after this case and the car could stall out on the highway and I have to react. And that's the point of why you're supposed to travel 2 car lengths behind a vehicle. That's the point of why when you're traveling at nighttime, you're supposed to have your headlights on.
Yeah, I mean, there have definitely been cases that have said that if you're traveling down a road in general, you got to be ready for anything. I think one question here is, does that really apply in a limited access expressway where the whole point of the expressway is that everyone goes certain fairly fast speed, and if traffic is moving unimpeded, you know, most people don't expect there to be a stopped car in the middle of the expressway without its lights on. So I mean, that I think is and you know, I mean, I take your point that, well, maybe that's still something for the jury to think about, but I also think it takes this case distinguishes this case from some of the others involving rear end accidents.
I mean, you can get a ticket for driving too slow on the highway. That is true.
You can get a ticket for driving too slow, you can get a ticket for driving too fast. I think in this case, defendant Singh was driving at night in a construction zone, a situation that reasonably calls for a heightened caution. It is disputed whether defendant Singh or undisputed or disputed rather defendant Singh maintained a safe following distance, kept a proper lookout, or exercised due care under these conditions.
The testimony, though, that we do have on the record, he was driving the speed limit, though, right? The truck driver?
That's his
How do
testimony.
you travel a safe distance behind a car that's either stopped or idling?
Well, if he was traveling, our submission is if he was traveling a safe distance 2 car lengths behind, first of all,
Behind a
his
stop. Okay.
I mean,
It
you'd
doesn't
have
make any
to you'd have
sense.
to take the position that a truck driver going down a dark expressway at night needs to be driving slow enough so that if a car like this just pops up, not moving at all, that you're able to stop. And I mean, I think, I don't know. It seems like trucks would have to go really, really slowly if that's the rule.
Understood, Judge. My whole point is just the fact that it was a rear end collision, and that in and of itself creates a prima facie case. I think whether a defense applies should be a question for the jury to decide.
Thank you.
Thank you.
All right, good morning and may it please the court. My name is William Cook. I'm here for the defendants, Gig Express and Gurpreet Singh. I think I just have 3 points I want to make, and one is one you've already hit on. There are no disputed facts here. The plaintiff and the driver of the Jeep that was in front testified they don't know what happened. So all we have is the evidence of the video and the testimony of our driver, all of which are consistent and show the same thing.
Well,
We have-
just go ahead and answer if you don't mind answering the same question that I asked brother counsel there, how do I line up these different presumptions, right? There's the new contributory negligence rule. There's the presumption that if you rear end somebody, you were negligent. And then there's the sudden emergency. I mean, we all watched the video. The video is pretty, I thought it was pretty clear what happened. It's hard to argue with the video, but why doesn't this go to the jury?
Sure. I think the answer to that is, so the sudden emergency defense, as I understand it, is it overcomes the presumption. I think the Michigan Supreme Court said that, this court said that in numerous opinions, because the rear end collision statute is a rebuttable presumption. So the sudden emergency defense, if it applies, overcomes that presumption and says the defendant driver was not negligent in these situations, and we can decide this issue as a matter of law if there are undisputed facts. And that's why we cited some cases in our brief where trial courts have granted summary disposition based on the sudden emergency defense applying, and this court has affirmed based on those same rules. So if that can be decided as a legal matter, that overcomes any kind of negligence, it overcomes any kind of presumption based on the rear end statute. I think the law has been pretty clear that that is what it says. So that overcomes any kind of presumption of the statute. So that was one of the third points, so I'm glad I got that taken care of. But I think there is no factual dispute. We've seen the video. You can see that the driver of the semi-truck is driving down the road. Traffic is moving, normal highway speeds. And then all of a sudden, 1 to 2 seconds before the collision, you see the brake lights on the vehicle in front of it. The truck driver does indeed hit his brakes, but there just is not enough time for him to be able to stop in time before there's a collision. And so the trial court described this as a bang-bang situation. I think that's a pretty accurate way to describe it. And this
I'm sorry, what?
So the trial court called it a bang-bang situation. I think what he was referring to is that there was very little time from when the Jeep that was in front hit its brakes where you could see that it was stopped or not moving to when the actual collision happens, right? I tried to slow down the video as close as I could, and I got that it was about 1 to 2 seconds from when we first see the brake lights until the actual collision happens. So that's very little time, and I think this fits very clearly within the unsuspected part of the sudden emergency defense, which shows that you need a peril that is not in clear view for a significant length of time, and that's totally unexpected. And so this peril was not in view for a clear length of time. It was 1 to 2 seconds. We can see that from the video. That's also what Mr. Singh testified to at his deposition. And it was totally unexpected for the reasons I think the panel's already discussed, which is that it was nighttime, traffic was moving regularly at normal highway speeds. There was no reason for anybody on the road to suspect that one random vehicle was going to be stopped in the middle of the expressway. There was no indication of that based on traffic or anything from the Jeep itself until its brake lights illuminated. And that's when the truck driver did hit his brakes.
One thing I did notice, and I'm not sure this makes a difference, but the dash cam video is being taken by I assume a truck, some sort of vehicle on the right lane, traveling down, and the defendant vehicle, the semi truck that's your client's truck, is traveling to the left and is moving slightly faster than the truck that's taking the dash cam video. And now I know defendant testified, well, I was going 55 miles an hour or thereabouts. But if he's moving faster, that means that either the truck that's taking the video is moving slower than 55, so going under the speed limit, or the defendant is mistaken about how fast he was going and actually he was speeding. I mean, is that enough for a material fact?
I don't think so, because all we have testimony about the speed is just from the driver himself, right? We don't have any kind of hard data that you sometimes get in cases involving trucks or other vehicles. That's all we have. And we know that 55 was an appropriate speed based on the law, and that's not causing any issue. I've not seen any authority that would support that was unlawful, or that he was negligent, or that his speed was going too fast. There's just not any evidence in this case, I think, to support that. So I think the last point I want to make is that we cited some prior Court of Appeals opinions, although unpublished, in our brief that present similar factual scenarios where this court said the sudden emergency defense applied. Those largely involved stopped vehicles that abruptly stopped or suddenly appeared in front of the defendant. And this court said, yes, we will grant summary disposition, or the trial court said they'll grant summary disposition. This court affirmed and said, this is appropriate to dismiss these cases. I think this case presents a pretty similar factual scenario than those, and that makes summary disposition appropriate. And we ask that you affirm the trial court's opinion.
Thank you.
Thank you.
Thoughts, rebuttal? Just briefly, Your Honor. Of course.
I think the court raises a good point about the testimony, that it is a bit self-serving for him to testify. I'm doing 55 miles per hour. I think anyone who travels, it is really, really difficult unless you have your car in cruise control to actually maintain the exact speed limit. I think when you're driving and traveling, that it fluctuates at times. I think the fact that the sudden emergency doctrine is so fact specific is the reason why, if it's going to be used as a defense, it should be submitted to a jury. The Michigan courts have held that the sudden emergency doctrine is an extension of the reasonably prudent person standard. Determining whether a defendant Singh acted reasonably or acted prudently requires examining the specific circumstances in his conduct leading up to the collision. In similar cases, courts have held that factual disputes about whether an emergency was truly sudden or unavoidable to fall under the statutes are questions for the jury to decide. And here, a jury could reasonably find that the defendant Singh failed to respond appropriately to the foreseeable conditions. And with that, Your Honor, we just ask that we reverse the trial court's decision.
Thank you.
Thank you very much. That case will be submitted.
Well done, both of you.
For the next case on the docket, the last one for the 10 o'clock is item number 21, Desmond Ricks versus State of Michigan, docket number 369531.
Morning,
Good morning.
Rob Kamenak. I represent the plaintiff appellant. I'd like to reserve 5 minutes for rebuttal. I don't think I'll need it, but I'd like to reserve it. The court knows this is a wicked case involving my client, who is wrongfully in prison for over 24 years. This is, as far as I could tell, this is a matter of first impression. And that is the proper interpretation of what's called the reimbursement or the set-off provision of WICA. And that's found in Section 5 of WICA, subsection 13. The court has it in front of it, I'm sure. As with all cases on appeal, I have to assign error. And I do that cautiously because this is a matter of first impression. And I also do it cautiously, but nonetheless directly, because I have great respect for Judge Schwartzel. Lots of cases, and he and I have been around the block a few times in a good way. So I'm not critical of him, but there is a flaw here. And the flaw, I
You can
believe,
be critical of Judge Swartzel anytime you want. We don't mind.
I may have to appear before him again. These things are recorded.
I couldn't help it.
I understand. But nonetheless, it is a matter of first impression. He was very gracious, I'll say, about giving us a hearing and supplemental briefing and all that. But I think the difficulty when I went through this is he excised all notions of equity out of the set-off provision. And he's pretty,
Well, why does equity come into play when you're interpreting a statute?
well, I think,
But let me.
Sure.
Before we get to that,
go ahead.
you have in your brief the void for vagueness doctrine.
Which I was going to rely on the brief, but go ahead.
Okay, so that means that you don't really think it's a strong argument.
No, I just think that it's fully explained in the
Let me just
brief.
ask the question, because in looking at this, I don't see how that applies, because and please tell me if I'm wrong, because I've known you a long time. You know I've been wrong. all the cases seem to say that it only applies to a statute, whether civil or criminal, that prescribes conduct or has a penalty. And that's why the void for vagueness doctrine exists, so that the general public doesn't, they need to know what the standards are before they're told not to do something, or they're going to get penalized for it. And this statute isn't that type. So why would that doctrine even apply?
Well, the set-off provision, I
Not a
would,
penalty. It just says
Well-
you got to give the money back if you get money from somebody else. It's not a penalty. It doesn't prescribe conduct. Not in the sense that all these cases talk about.
doesn't prescribe conduct, I would agree.
What's
but
that?
I-
I'm sorry.
I'm sorry, I agree that it doesn't prescribe conduct, but I do think it acts as a penalty. Because at the end of the day, the judgment that Mr. Ricks would get for the federal court stands. He doesn't get anything from the state at all. In my mind, he is essentially penalized. If he didn't have the federal court action, the state would give the money, which you know the dollar amount that's in the brief, and that would be that. But it's suddenly, since he has a federal court action, I do believe he is being penalized because he's got to return all the WICA money. That's the best answer I can give you.
Okay.
Seriously.
Yeah, I believe it.
Yeah. And so I understand, one of my old mentors that some of you may know, John Jacobs, always told me that in a civil case, resort to a constitutional argument is the last desperate gasp. I understand that. Nonetheless, I do think it still applies.
Well,
But-
one way or
but I-
another, we have to, whether we do the vagueness doctrine or just statutory interpretation, we do have to figure out what the statute actually
Absolutely.
requires, one way or the other.
So you've got constitutional here that we just talked about. We've got interpretation here. And the difficulty, I believe, is that number one, it's a technical statute. Under MCL 8.3A, you're supposed to interpret technical words technically. None of them are defined. So,
Yeah, I think the difficulty is it seems pretty clear that from WICA, there is an intention there, whether it be equitable or not, to claw back that payment. But in terms of, you're talking about equity, in terms of equity, I was intrigued, but wanted to hear, so maybe you'll get to it in a bit, and I should have just let you go. But
please ask.
I was intrigued by your argument regarding whether or not about the private attorney general. Explain that to me. I think when I read it the first time, I don't think I've ever seen this before.
Well, I will tell you that, again, I updated everything. I think this is all first impression. I didn't, and I may, correct me if I'm wrong, but I didn't find an opinion that talks about this one way or the other. That's why I did go, if I'm addressing your concern, I did go and look at statutes because WICA's in like 35 states, the equivalent of WICA. And I went and looked at some of the interpretations of here, you can call it a set-off provision or reimbursement and see how they work. And one of the things that I noticed is our statute is silent with respect to that portion that counts towards the reimbursement. I think that's what you're driving at, but I might be wrong.
But I mean, WICA there is this clear intention to partition off attorney's fees from the settlement within WICA itself, right? Because there's a separate provision for getting your attorney's fees through WICA. But the the clawback provision doesn't seem to speak to that. And I'm trying to wrap my head around what to make of that.
I take a slight left turn on what you're saying, if I may.
Okay.
The set-off provision doesn't address attorney fees at all. Admittedly, the language isn't there. I've given you the Ohio statute where the language is there. So our statute is silent. And the question is whether, when you're talking about the damages obtained in the federal court action, whether you look at, I'll finish up and then I'll try to answer. Whether you're looking at that portion of the federal court recovery that actually goes to Mr. Ricks here, or whether or not you have to excise the attorney fee portion of it. Well, that's the argument in any event that we're making. So maybe I'm not addressing your claim. Now, the statute does provide that, you know, you can get a limited amount of attorney fees in addition to the WICA award. I agree. But I believe that's a separate concept from from what I'm talking about.
Yeah, doesn't WICA give you like 10% of your attorney's fees and you have
Yeah,
to
and-
like apply for it?
Right, if you
That's what I
apply
was talking
for it,
about.
and here, and if I may, Your Honor, here, I think the award was 20,000, and later on, there was a supplemental award, and that was like 30,000, but it's
You
minimal.
started, you were, I'm good, because you made me think I was crazy for a second.
No.
No, WICA has like a separate provision for attorney's fees, right?
Just a different,
Yeah.
different animal of attorney fees.
Well, yeah,
Okay.
and that made me think that they were like saying, okay, we're gonna think about these things and, you know, differently, but but you don't have to pay that back, right? Like, so that's where I was getting at. So with, maybe I'm wrong about that. You can correct me if I am, but like, when you get to claw back WICA in the statute, that would be completely different than the attorney's fees. You don't get to claw back the attorney's fees.
That is my understanding. But
Right,
those
so
are
that
the-
made me think about the attorney, that private attorney general, that private attorney action,
Mhm.
and say, well, wait a minute, maybe that does have some teeth to it because they're, you know, you're not trying to claw back the attorney's fees. You're viewing them through a different lens. Maybe
No.
I'm just not making my,
I think,
my thoughts very
I
clear.
think there's
but-
linkage there, if I may use that term. But most of the Attorney General argument candidly came from the way we handle liens. I'll just tell you, and those who have been, I'm still relatively new in this position of handling liens because of my prior background. But usually what happens in that situation is that when you go ahead and get a recovery and the lien holder gets the money, there's usually a discount, and usually it's a third. That's just custom practice. You may know that. In essence, this is an analogy to that. Now, I presented it in the vehicle of a private attorney general because at the end of the day, what's happening is that the state is getting money back based on the actions of private attorneys who brought the federal court action and got the money. So that's the concept.
If the settlement with the city of Detroit had said, and I understand settlements with the city of Detroit don't tend to say this, but if it had said, you know, it's going to be, you know, $250,000 in damages to the daughters and, you know, sorry, we're talking millions here, 2.5 million to the
Mhm.
daughters,
Mhm.
5 million, what was total, 7.5?
7.5.
Well, excuse me, I'm obviously not doing the math very well, but if it had said, oh, and this amount is going for attorney's fees, I think we'd have a clearer picture of kind of how this
We
all should
would.
work.
And
Instead, we have 7.5 million lump sum. Whether we count all of that as damages or not, I think might depend a little bit on section 1988 and how that plays into to attorney's fees. But my question actually is that Judge Schwartzel, I was going to say asked, but he actually ordered you to provide a breakdown of how much money went to the daughters and how much money went to Mr. Ricks. And I believe you did provide a breakdown if it was a third that went to attorney's fees. But how come we never ended up kind of seeing how it all broke down?
Your Honor, the record does not have an indication of once the money was paid after the attorney fees, and we all know how that works. You subtract the cost, then you subtract the attorney fees, and there's your balance. The record doesn't contain that. I would agree with you. The only thing I can tell you in response is that you've got the document of the release, and you also have the letter from the city of Detroit indicating that it was jointly paid to all three of them. There is
So if
no.
we took we know how much got taken off the top because that was, I don't know if it was verified or not, but it was, your side represented to the court how much was
Right,
taken off the top.
and I'm going to interrupt. It's in our brief, page 14, in a footnote. Go ahead.
We take that off the top
Mhm.
and then if we divide up the remaining amount by proportionally what was asked for in the complaint, in the
Federal court complaint.
yes, in the federal court complaint, right?
I'm sorry.
50 million for Rick's and 12.5 each for each of the daughters, I think it
Well, the
was.
First Amendment complaint, I do not believe, I've got it here. I don't think it broke it down. And two, if I may, and I'm not trying to interrupt,
Okay.
let's be clear, because the federal court case settled.
Right.
So we don't have, I am interrupting, I'm sorry, but we don't have a breakdown of how the jury would award the ultimate amount of damages. We don't know if the 7.5 reflects damage work as a settlement. And two, we don't have a breakdown of per plaintiff. Go ahead.
We have no idea how
Correct.
they decided to do it, but your side was asked to tell the court how they actually did it, and that information was not produced. But if we divide it up according to what was asked for in the complaint, and we do all the subtractions, it seems like your client is still left with more than 1.2. And that suggests to me that maybe, and I think this is what Judge Schwartzel was doing, we could basically decide this case without maybe deciding some of the really harder questions, like what if the total amount is, what if the total amount recovered in the federal case is only 2 million or something like that? What do we do then?
I agree with your analysis. I think that's why he didn't jump into some of these interpretations that he addressed many of them, but not all of them. But at the end of the day, what we did ask for is an allocation hearing. And Judge Schwartzel said, I don't need it. This is my interpretation of his opinion. I don't need it. And I think he gave an example. I don't know if it was in the opinion, but certainly in the transcript of let's divide it up by thirds. And bear with me because I've got the calculation here if it helps. I think what he did is said, okay, let's assume that I agree we're going to take off the attorney fees. And that's not a portion that is subject to the reimbursement. And then let's assume that we cut it into thirds. I think that's pretty much what he said.
That is what he said.
Right.
He said, then there's still enough money.
And there's still enough money.
Yeah.
Right. And I think that came out like in 1.652 million. And as you know, the WIC amount was 1.231 million. So I'm an English major, but I did do the math here. Okay. And so the question, all good points. The question is whether or not in an allocation hearing, what would happen? And I ran the numbers if it helps the court. And if by way of example, if 1/4 of the money that was actually obtained, and we're talking about keeping the attorney fees out of it, it's basically a wash. So if 25% went to Mr. Ricks as opposed to his daughters, and I'm going to tell the court I did it, it's basically a wash. For it to have significance, you have to get it down to 1/5, basically. So I'm an officer of the court. I wanted to tell the court that. I did it. At 1/5, it comes out to about, the reimbursement amount would be about $991 in my figures. And of course, the WIC amount was 1.231, so there'd be a savings. So yes, I understand the challenges on the math, and I understand why the court did not address it. Perhaps I'm not addressing your question.
No, I guess, other than your argument that the whole statute is so vague that we just have to sort of toss the whole thing out and say that the state can't collect. I'm just wondering whether some of these thornier issues really need to be decided in this case, or whether they should wait for a case where the federal settlement is low enough so that it actually makes a difference in terms of how much needs to be reimbursed to the state.
The key point being whether it actually makes a difference, if I may. And again, if the court is perhaps going down the road that you had your chance and you didn't take it, I understand that. But what we did do in response to that, because I've been through this in workers' comp liens and everything else in my career, we did say, wait a minute, until we actually know where the money went, we really can't do what we just talked about. We just can't do it. You have to have a hearing. You have to bring the people in. You have to figure out where the money went. Did Mr. Ricks give the money to his daughters? Did he buy them a house? Did he pay for their tuition? We asked for all of that. And I understand that it may be an uphill battle, but we're still entitled to that. And then If we're entitled to that hearing, these other issues become pertinent. That's other than the Attorney General, private, knock off a third off the top. So I've got more, but I don't know if it's worth going into at this point. Sounds like the court has a pretty good idea of what goes on in these cases.
I have another question, and I'm not sure it's squarely before the court.
Okay.
But you typically take a third of a damages in a settlement. You typically first cut off expenses.
Correct.
And then you take a third as your contingency fee.
Correct.
That's my understanding.
That is correct. And that's what happened here.
Right.
But again, I want to stay in the record.
Yeah. I guess one question is, it seems like the public policy of WICA is that in the compensation that's given to the plaintiff, that the attorney is not supposed to take attorney's fees out of that compensation.
Out of the WICA compensation.
Correct, right?
I think that is the case.
You're supposed to get your own, there's a fee shifting, which is not very generous, but it's there. And then there's a part of the statute that says, oh, and also the attorney cannot take money out of the compensation.
That is my understanding.
So if that's the case, if Mr. Ricks has to reimburse the state 1.2 some odd $1 million, doesn't that mean that counsel should recalculate the total amount of the settlement in terms of how much money you take out in terms of your third? In other words, don't you then say, okay, it's 7.5 million minus 1.2 million, and then from what's left, you chop off the expenses and you take a third of that.
I
Because
understand.
otherwise, you'd be dipping into the WICA amount in order to take your third. Does that make sense?
Does, but I'm not sure I agree with it, but I understand where you're going. I wish I'd give you something better than that.
And I'm not sure it's before us, but it's something that occurred to me as a potential consequence of this whole thing.
So we've gone through a fair amount. If the court has any further questions, let me see if I can address them. I wanted to leave you on one point because I did look at other states' WICA provisions. I did look at the federal case law. I did try to look at other reimbursement provisions, and I'm just going to go back to my original point. This is Justice Kagan in a case a while ago. She was talking about reimbursement provision in an ERISA health plan, because there's reimbursement provisions in those, really complicated stuff. And she said, and perhaps this addresses Judge Murray's point, while equitable rules cannot trump a reimbursement provision, they may aid in properly construing it. And that's kind of where I'm going on this.
But you are not the attorney down below, right? Like you're just the appellate attorney?
Correct. I helped on one of the briefs. And we also were not the attorneys that prosecuted the WICA.
Right,
That was a different law firm altogether.
right.
Okay.
Okay.
I'd ask the court to reverse and figure out exactly what it wants to do on this.
Thank you.
Thank you.
Good morning, Your Honors. Assistant Attorney General Adam Roos, appearing on behalf of the defendant appellee in this matter. I'm happy to go in any direction the court wants to go if there's questions. Couple of quick points I just kind of wanted to make. As noted, this case turns on the proper interpretation and application of subsection 13 of the WICA. And that subsection really reflects the legislature's intent and commitment to not just provide compensation to those who have been wrongfully imprisoned, but also to ensure that receipt of the WICA award or the recipient of the WICA award does not receive double recovery for the same wrongful imprisonment. The statutory scheme enacted by the legislature was limited and conditional. The WICA places other conditions on the award throughout the statute. the appellant in this matter, rightfully received his $1.2 million. But by accepting that award, he agreed to those conditions. And one of those conditions is subsection 13, which requires reimbursement when and if he gets damages or if he obtains damages from any other person and for the same wrongful imprisonment. And that's exactly what we have here. So, we're asking the court to affirm the decision of the Court of Claims and find that subsection 13 does require full reimbursement to the state. Address a couple of things that were raised by Mr. Ricks's counsel here. This provision may be a matter of first impression with the court, but our Supreme Court has interpreted other provisions of the WICA. And most notably in a case involving Mr. Ricks, the court essentially, to determine the legislature's intent, and I think that's what we need to do here, looks at the text of the statute, obviously, and the context in which it is set, and the purpose of the subsection. And given those factors here, I think the law is clear that full reimbursement is required to the state.
You'd agree, would you agree that if we did know how much money went to the daughters, that amount would not have to be contributed to reimbursement? Well,
As to allocation between separate plaintiffs, Your Honor, I think the language of the statute doesn't take that into account. It doesn't say damages obtained by the plaintiff. If you look at...
Yeah, but the point of the statute is you don't want the same individual double dipping, right? Like there was a completely separate action filed for consortium on behalf of those other plaintiffs. So that doesn't seem in the least bit in line with the intention of what the statute's trying to accomplish.
Maybe not, but the language of the statute says for damages obtained for the wrongful imprisonment or conviction. So if those damages flow from the wrongful, I don't mean to interrupt, if they flow from the wrongful imprisonment, I think under the terms of the statute, that's what we get. A couple other points.
I mean, really, if the settlement agreement said this, instead of a lump sum 7.5, if it said, okay, 1 million goes to daughter number 1, 1 million goes to daughter number 2, 5 million goes to 5.5 million goes to plaintiff, you'd really only be looking to the plaintiff, right? I mean,
well, I think the language of the statute reflects the reality that the award from the federal case, granted in theory, it could be less than the award from the WICA, but I think it reflects the reality that the award from the 1983 action will always exceed what the WICA is gonna provide. And I don't think...
And maybe in another case where it's close, it'd be a tougher call.
It could be a tougher call.
You don't think that the WICA would ever want to put the plaintiff in a position that was worse after, 20 years of unjust incarceration? You don't think it was the legislature's intent to put him in a position that was worse than when he started, right?
Well, given the language of the statute, I don't know, and I don't know if the court needs to reach that decision today.
Probably not.
So it is a bit of a thornier issue.
Not a winning argument either.
Understood. A couple other points I just wanted to hit real quick. As the court pointed out, Mr. Ricks was given the opportunity to proffer evidence in the Court of Claims to come up with this allocation. It never came. The first I've ever seen of it is, as his counsel mentioned, is in a footnote in the brief, as to what were the attorney's fees and to what were the costs and to what the net amount after attorney's fees was. There was never anything in the record regarding that. And as far as an allocation hearing, Judge Schwartzel did want to have that. And when the evidence didn't come, that's when he said, okay, I'm just going to at minimum chop it up by a third, at minimum. I don't think under any universe of logic did Mr. Ricks get less than $1.2 million here. And I think that's what really requires him to reimburse the state. Unless the court has anything else, I would rely on my brief.
Thank you very much.
Thank you.
Anything in rebuttal, Mr. Kamek?
I'm just curious. Can you, I meant to ask you before, how do taxes work on this?
I'm sorry,
How do income taxes work on these, on the WICA awards and on this award? Do you know?
on WICA awards, I don't know.
Okay, what about this one? Do you know? On the federal award, sorry.
I don't think there was an income tax consequence given, probably given the terms of the settlement agreement. I don't know for sure here. Usually it's worked out in terms of how the damages are bucketed, not by person, but by nature, and whether or not they're bucketed in such that they're not taxable. It's the best I can tell you.
Okay, thank you.
I only have one point, and that goes back to my original point. We talked about interpretation of statute. This is a remedial statute any way you cut it, and I think it's wrong. Strike that. I think it's incorrect to interpret WICA altogether as a remedial statute and then suddenly pull out the set-off provision and say, no, it's not a remedial statute. Because I think that's exactly what happened here. And when you have a remedial statute, as the court knows, it's liberally construed in favor of the persons intended to benefit from it. And that's Mr. Ricks.
Thank you very much.
Thank you,
This
Your
case will be submitted.
Hmm.
And we're going to take a break. We will be back to resume. For your patience, we are back and we're here to begin our 11 o'clock docket. And we're going to call item number 22, case number 367151, Jeffrey West versus Sharice Spink. I believe we have oral argument remotely from the plaintiff.
There we go. Sorry, Your Honors. Good morning. Michael Corcoran, P 41254, on behalf of the plaintiff appellant.
Morning.
Morning.
Whenever you're ready.
Thank you. First of all, I want to thank the panel for allowing me to attend by Zoom. I appreciate that. I had a conflict, as I pointed out. This matter was tried in 2022. It was over the course of 3 different trial days, over the course of 3 months. This was Judge Thomas Power's very last trial, as I understand it, very last opinion that he wrote. I have a great deal of respect for him. I practiced in front of him his whole career. I just want to go through the issues real quickly because there's several. And if there are questions, certainly you can jump in. But the first issue I raised, Your Honors, is that the judgment was against the great weight of the evidence on the partnership claim and the request for an accounting and dissolution. This was 2 individuals, my client and the defendant, who had a relationship for almost 20 years. Part of it was romantic. They had 3 kids, but then all of it was a business relationship over the course of those years. At some point in time, after my client had severely injured his back, received a big settlement of $400,000, he and the defendant, they started putting their resources together to acquire properties, real estate, make improvements to properties, flip properties. A lot of these properties were originally acquired in either their individual names or both of their names. At some point in time, they became acquainted with the other co-defendant, Mr. Dunn, who was essentially, as Judge Power suggested, practicing law without a license. And he suggested that they put everything into a trust, which they tried to do. And we're talking about 33 parcels of property, real property, a storage unit business that was essentially built during this time, the building of which was supervised by my client with dozens of storage units. It's a thriving business as we speak today. It's called His and Her Storage, which was the plaintiff and the defendant. So this was all these properties were part of the partnership. Defense claimed there was no partnership documents. I've argued in my brief there was plenty of indicia of partnership there, including the failed trust agreements and including 7 disinterested witnesses who testified on behalf of my client. It should be pointed out that the defendant presented no proofs in their case in chief. The defendant did testify as an adverse witness, but that was literally the only adverse testimony. You know, the testimony was that my client did supervised years and years and years of acquiring these properties, flipping them. They would generally when they'd sell a property, they'd take the profits and put it back into the business to grow it. And that's what happened until the parties started to break up after this failed trust agreement. And it took several years of trying to negotiate around it. Eventually, a lawsuit was filed. We believe the evidence did establish a partnership, that my client would have been entitled to an accounting and then a formal dissolution. The other claim that we brought was if the court didn't believe that there was a partnership, that there was a claim for unjust enrichment. And because of the statute of limitations, our proofs only were limited to everything after January 13th of 2015. But the proofs, again, with 7 uninterested witnesses and my client and lots of documentation, including testimony from the defendant, that he continued to work for the business, continued to provide services. And unfortunately, Judge, when he rendered his decision, I think it was fairly ambiguous because on the one hand, he says, well, we didn't have a claim for unjust enrichment, but yet he awards half of this campground to my client. So it's hard to determine whether or not he agreed that we had an unjust enrichment claim or whether or not the proofs would have given rise to another cause of action or another claim, which we could have addressed in his opinion and amended to conform to the pleadings. But at the end of the day, my client's improvements, all the work he did after 2013, also $250,000 worth of improvements he did to a building called the Blue Barn, were just discounted by the judge, not really allowed to even present proofs. And then lastly, during the course of the litigation, counsel for the defendant obtained an order from Judge Power that said that my client had to vacate 3 of the storage units at this His and Her Storage that he had occupied for years and years and years and literally turned them into residential units. They had a bathroom and heating, etc. Well, with that order, the defendant went out there on at night, one night, and just emptied the place out. We had $53,000 plus worth of damages in terms of property that was removed, and Judge Power would not let me get into those proofs or even amend the claim to present a claim under the Self-Storage Act, under the Landlord-Tenant Act, because there were people living in these storage units. He just would deny my ability to ask for any relief on that. The third issue was it relates to similar to what I was just talking about, is that the judge ultimately awards half the campground to my client, which is essentially an acknowledgement of the unjust enrichment claim or some other theory that he doesn't enunciate in the opinion. As I point out in the brief, awarding half the campground was just not really, it doesn't do much for my client. this is a campground that my client had acquired with the defendant. And what he was doing, Your Honors, is that he was bringing old cabins and other structures to the 4 parcels. And he's a former vet. He would have veterans come up in the summer and stay there to get essentially respites. He would have programs, veteran-related programs. So that was his dream with regard to this campground. So without all 4 parcels, he can't live the dream. It can't be done. The water system is connected from the other side, lots of impediments. But the problem is that the judge only gave him essentially half the loaf on that. And then at the same time, judge just literally, as I indicated, would not hear proofs relative to the $250,000 of improvements my client made to the what's called the Blue Barn. Which leads me to my next issue. The number 4 was that the judgment contained a mistake because the judge says there's no cause of action establishing unjust enrichment. At the same time, he grants us partial damages for 2 of the 5 campground parcels. I mean, I think both can't be true. There's probably either a new cause of action that the judge should have enunciated and allowed us to amend, or he was in fact acknowledging that we did have a claim for unjust enrichment. And the same reasoning applies to that personal property that was confiscated, the $53,000. We should have been allowed to amend at trial. I asked for it on the record. They clearly violated the Self-Storage Act in Michigan. When you have a storage unit, there's a process. If he was, to the extent there was somebody living in those units, you have the Summary Proceedings Act. These are exclusive jurisdiction acts, which neither one they followed. Quite honestly, after they got the order that said empty out the 3 units, I fully expected that the defendant would file a district court action to evict my clients formally under the law, which they never did. So the final issue is exactly that, is that judge did not allow me to pursue a claim for conversion, civil conversion, or violation of the Storage Facilities Act or the landlord-tenant laws. He just literally wasn't going to hear it. And I think that was error. So as I said at the beginning, I have a great deal of respect for Judge Power. I think it was difficult having trial over 3 different days, over 3 different months. My sense was that he forgot or didn't remember the overwhelming evidence that we presented on days 1 and 2. And that was reflected in the decision. So I'd ask the court for the relief we asked for in the brief, to the extent that the court needs to remand these matters down for further proceedings. Judge Hayes in Charlevoix was appointed for the post-judgment matters in this case after Judge Power retired. So with that, I don't have anything more to add. If the panel has any questions, I'm happy to answer them at this time.
No, thank you very much, counsel. We appreciate your appearance here today.
Thank you. Have a good day, everybody.
That case will be submitted. The next case is item number 23, Can Arbor Incorporated versus Department of Treasury, docket number 370919. We do not have appellant endorsed for argument, so we just have appellee. It's all right.
Good morning, Assistant Attorney General Wesley Margison, representing Treasury. I will rest on my brief, but I'm happy to answer any questions the panel might have.
I think I had a couple. Give me a second here. So So we have these two statutes, the MRTMA and I don't know how we're going to pronounce this, but MMFLA. In MRTMA, there's the scope of act section, section 4. And it says, this act does not limit any privileges, rights, immunities, or defenses of a person as provided in the, among other things, medical marijuana facilities licensing act. So as I understand Treasury's position, they said something like, well, we can't interpret not facilities, I'm sorry, what's the term that's being used here?
Marijuana establishment?
Established. We can't interpret establishment as meaning anything in the MMFLA because then all of the medical marijuana facilities are going to be subject to these more onerous requirements of MRTMA. That's how I understood that Treasury saying, and I think that the Court of Claims said that too. But how come we can't just say, well, this this limitation and this about the scope of the act will protect them from being subject to any of those requirements? Does that, and I apologize if I'm not articulating my question clearly.
I think I understand your question. At first, I would say, yes, we did argue that that interpreting the way that the plaintiff wants would subject potentially MMFLA licensed facilities to MRTMA requirements. That was part of our argument, but the main thrust of our argument is statutory interpretation, which is that if you read the definition of marijuana establishment to include MMFLA licensed facilities, that renders the specific license types listed in that statute nugatory, because the exception would swallow everything else. It would be then all you would read.
Can you give me an example of that happening?
Well, so in that section, it gives you different things. It gives you different license types, marijuana grower, et cetera. If we read it the way the plaintiff wants, and you read it any other type of marijuana related business licensed by the CRA, you don't. All of the rest of that means nothing because all of these places are licensed by the CRA.
So if they had meant that, they wouldn't have used any of those examples. They would just say an establishment means any establishment licensed by the.
Exactly. Yeah. So listing those license types is nugatory. And also, as far as the privileges question that you asked, our interpretation doesn't affect that. There are certain privileges given by the MMFLA. Our interpretation doesn't affect that, and you read the scope basically to mean that the MRTMA regulates adult use businesses and the MMFLA regulates medical businesces. So the MRTMA, that's consistent with our interpretation that the MRTMA stands on its own, except where specifically references the MMFLA and vice versa.
I mean, it makes sense, except for the thorny point about how medical marijuana establishments is defined in the statute.
You mean by marijuana establishments?
Yes.
Is that what you're
Yeah. Sorry. Yeah. Not because clearly medical marijuana establishments are regulated by the agency.
They are. But, as we point out in our brief, that catch-all provision can be read with the other provision of the MRTMA that allows the CRA to promulgate rules establishing different license types. So we can give meaning to all of that by saying marijuana establishments are only those licensed under MRTMA, and marijuana facilities are those licensed by the MMFLA. I'd also add that there is a specific statute that talks about both within the MRTMA, MCL 279583C, and that talks about a distinction between marijuana establishments and marijuana facilities, which is how the MMFLA describes its businesses.
Sorry, can you tell me that statute?
Sure. Sorry if I went a little fast. MCL 333.279583C. And that talks about limitations on the CRA promulgating rules prohibiting a marijuana establishment from operating at a shared location of a marijuana facility. So that provision alone shows that the MRTMA looks at those two things differently. Okay.
I have no other questions. Looks like my panelists don't either, so thank you very much.
Okay. Thank you very much.
That case will be submitted, and we will move on to item number 24, IIP MI 4 LLC and Livewell, Michigan LLC versus City of Warren, docket number 373070. Mr. O'Loughlin.
Thank you. Good morning, Your Honors. May it please the court, Seth O'Loughlin on behalf of Respondent Appellant City of Warren. Sitting here today, I understand you are very well read and prepared for these cases, so I want to use my limited time before you to highlight specific issues and recent developments in case law. When preparing for this oral argument and reviewing the briefs and reviewing the tribunal's decision, I think it important to note that this arose from a small claims hearing. This is a hearing with no transcript, with no witnesses, no cross-examination, and very limited exhibits. It's basically a 30-minute telephone conversation. And I think when you look at that, it explains how the tribunal reached the conclusions it did. And there are two conclusions at issue. The first is that there is a due process violation, specifically that the notice of denial for the exemption did not specifically indicate which board of review the taxpayer had to go to. That's issue one. Issue two is that marijuana is within the scope of agriculture. Now, these are two very distinct issues with a host of case law, briefing, and analysis as shown by the parties. My position is, and my client's position is, the tribunal got both of these wrong. And as to the first issue, the due process issue, the ability to waive the jurisdictional requirements, there was a lot of briefing by the parties. However, during the briefing, the Supreme Court decided 6ARP LLC versus Byron Township. That opinion, timing of which was slightly problematic because it was issued 2 days after Appellee filed their response brief, or their brief in response. Now, in appellant's response brief, we address 6ARP, but I think there are other portions of that case that are relevant. Specifically that in this case, what the tribunal looked at to get a due process violation was the four corners of the denial notice. They said, look, if you look at this denial notice, it's not detailed enough. It doesn't have enough information. But in 6ARP, the Supreme Court said that due process is flexible. And we need to look beyond the notice of denial itself. What other information did they have? What other notice could they have been provided? And so the tribunal's limitation of its analysis to the four corners of the denial notice, to me, is an error of law that justifies reversal, if at a minimum to consider what other information the taxpayer may have had, such that they could have gone to the correct board of review. I think the statute is clear. They had to go to July. They did not. They went to December. That creates a clear jurisdictional issue. Second, as to the due process issue, the tribunal basically said there's a due process.
Can I back up on there? Because, so the jurisdictional point is a question about the tax tribunal's jurisdiction or the Board of Review's jurisdiction?
It's mostly the tax tribunals, but the tax tribunals is tied to the Board of Reviews, because our position is that the Board of Review, the December Board of Review, did not have jurisdiction to hear the protest. And because that was the appeal that was then used to go to the tribunal, that the tribunal in turn lacks jurisdiction. The statute is quite clear.
Yeah, is there any case law about, because I looked at the statutes for the Board of Review and they don't use the word jurisdiction. The only statute that uses the word jurisdiction is the one about the tax tribunal. And so I'm just wondering if there's case law that I haven't seen that speaks to the Board of Review as being a body that either has or does not have jurisdiction.
I don't think you need case law, Your Honor. I think the jurisdiction itself is contained in 211.7 EE subsection 6, where it says you have to go depending on when the school tax is levied. And I think that jurisdiction may have been used by me as a catch-all term for courts, because the Board of Review, it's not a court. It's basically a small subsection of a local unit of government. And I think when you look at the way 6ARP interpreted the tribunal's overall jurisdiction, that it can be modified by these more specific tax statutes, that you have to look at one in relation to the other and then to the third to then say, well, tribunal, did they perfect the steps necessary to get there? Here in this case, they did not, and that itself is dispositive.
Because if the Board of Review requirement that you go to July rather than December, if that's not jurisdictional, I mean, the December Board of Review the assessor denied, the Board of Review denied the claim on the merits. They didn't say, oh, sorry, you came to the wrong Board of Review, right? They said you're not entitled to the agricultural exemption.
Well, it's difficult to say, Your Honor, because what happens when a Board of Review denies it is that you get this one-page form issued by the State Tax Commission. There's no record of the hearing. There's no explanation of their decision. It simply says we give it to you or we don't. And I think that's part of the evidentiary issue in this case, where the tribunal, what they really didn't address these thorny issues. They simply went to the four corners of the denial notice and said, well, you weren't specific enough. And that creates the issue, and now we can hear it. I think it would be a different appeal, Your Honor, entirely, if the tribunal had said, well, you know, the December Board of Review, they probably shouldn't have heard this, but they did, and they didn't deny it based on a jurisdictional ground. It would be a different case. But in the final opinion and judgment, the tribunal said, look, this is the issue. It's the four corners of the denial notice, and that is a legally erroneous way to look at whether or not a due process issue exists. And then for the tribunal to find there was essentially a due process issue, the tribunal does not have the power to do that in the first place. They don't have the power to say, well, you were deprived of due process. And I think that's been well established, but it's more important in the context of a small claims hearing where you don't have these witnesses. The city did not have discovery. We didn't have cross-examination. We didn't have interrogatories, depositions to really flesh out these issues for the tribunal to go in and make a due process, a fundamental constitutional claim that they don't have the power to decide in the first place. So that to me was a clear legal error by the tribunal.
The other side makes the argument that 211.7 EE6 doesn't apply because the assessor determined that the property was not qualified agricultural property. And that statute seems to be dependent on that. What's your response to that?
Well, I think that 211.7, I think that when you look at 211.7 EE6, the second sentence in there is the one that applies, where if it's denied by the assessor, you have to go to the July or the December
Yeah, but it says an
board.
owner that is a property that is qualified agricultural property. And I thought that the assessor had said in the correspondence that it was not qualified agricultural property.
And that is why they then had to go to the board. I mean, that's the way the tribunal interpreted it. The way I interpret it is that if you go to the second sentence, the first sentence says, if you have a qualified agricultural exemption, you've had it in the previous year, it's carrying forward, or strike that. If it is already determined as qualified agricultural property, then you have one method. But the second is if a assessor says, you know, you don't get it, you then have to go to the July board, the tribunal.
And I see, yeah.
So I will admit, Your Honor, it's not the it's pretty common in this property tax realm to have these very complicated methods of, well, if this happens, you have to go here. If that happens, you have to go here. You see that with residential property where you have to go to the board. Commercial, you don't. You see that with the
By the assessor saying that it's not a qualified agricultural property, that is denying the exemption.
It is denying the exemption, and then the
And
step
that's
that,
what kicks in the second sentence.
yeah, and then the step that you would then have to follow is you have to go to the correct board to then go to the tribunal. And as I was saying, this is not limited to just agricultural. You see this replete throughout Michigan's property tax system, where there are these procedural steps that must be followed, and failure to follow them has consistently been held to be dispositive on the issue of jurisdiction. Now, moving to the second issue, which is the marijuana. And to me, Your Honors, this is the thornier and trickier issue, because the Supreme Court has established that an exemption is available only when the legislature expressly exempts that property from taxation. And this is an exemption. If you are a recipient of the agricultural exemption, you do not pay the school mills. You are exempt from that millage. And so when you then go into MRTMA, as it was referenced in the earlier case, or the MMFLA, it becomes this kind of warren of, well, some parts say, to my mind, and as we presented in our argument, it explicitly defines it as commercial. Well, commercial is not agricultural. As presented by the other side, it is, within the scope of agricultural, but when the Supreme Court said it had to be expressly exempted, that's nowhere in the statute. Both the Medical and the Recreational Act address taxation extensively.
Well, these statutes weren't written post, or were they? I don't think so. They weren't amended post the proposition that legalized either medical or marijuana.
I do not believe they were amended substantively. I think they may have been amended in a minor way, but they weren't amended substantively. And to your point, Your Honor, that goes to the fact that at the time the agricultural definition was established, marijuana was illegal.
But there are all sorts of things that aren't mentioned in the the agricultural exemption statute that are nonetheless meet the definition of agriculture.
I would agree, Your Honor, but when you look at other places in the law, there is some express intention by the legislature that those things that are not named, maybe in the Tax Act, but maybe named somewhere else, should be exempt. And when you go into the Medical and the Recreational Act, when you see so much analysis of taxation, so much analysis of where the revenue is going, if the legislature had that intent that this should be included under agricultural, why would they not say so expressly?
Well, because I think they talked about excise taxes. They didn't talk about property taxes.
That's fair, Your Honor, but they did talk about about revenue from taxation of marijuana going to schools. That was something.
The excise tax.
The excise tax.
Yeah.
And so if you are going to discuss the excise tax,
who's to say they weren't thinking, well, a lot of this is going to be agricultural, so they're going to get an exemption. So to make up for that, we're going to impose an excise tax.
you could argue that, Your Honor, but when the standard is expressly exempts that property from taxation, that was the Supreme Court setting that standard. I think when you have to go in and say, well, maybe they were thinking this, maybe they were thinking that, we don't really know what they were thinking. And we're having to substitute our own kind of reading for it when the standard is expressly exempts. The legislature was silent. Maybe you can read something into that.
Well, I mean, in the actual statute, 324.36101, they list berries, herbs, flowers, seeds, grasses, nursery stock, fruits, vegetables, Christmas trees, and other similar uses and activities. I mean, that's an expression of the legislature's intent. It doesn't say marijuana, but it also doesn't say lots of other things that probably fit within that definition.
I will agree with you on that, Your Honor, but when you look at 324.36101B, you do see some very specific denotions. You see, it does say grains, feed crops, and field crops, for instance. Now, grains would probably include feed crops if it was meant to be read generally, but then why have that if it's meant to be read more specifically? You have nursery stock. Would a nursery stock not be within the scope of something else above it? You have poultry and poultry products. Why would that not be within livestock, which is a definition that follows it? I think it's not the clearest statute, Your Honor, but when you see things specific as Christmas trees, I mean, that's a highly specific plant. It's not a fir tree. It's not a general tree. It's a Christmas tree. If the legislature expressly wanted to include marijuana, why not put marijuana in there? Because marijuana, it's not like anything else in this 324.36101B. You can grow 100 Christmas trees on your property if you want to, but you can't grow 100 marijuana plants because it's a very highly regulated product. And so if the standard is expressly exempt, the legislature didn't expressly state anywhere that it was meant to be. I think the only reading consistent with what the Supreme Court has said we have to do is to say that no, it's excluded. And with that, Your Honor, Your Honors, I will rest on the brief unless you have further questions and reserve any limited time for rebuttal.
Thank you.
Thank you.
May it please the court. I'm Jackie Cook, appearing today with my colleague Christina Grossi on behalf of Applebee's IIP MI LLC and Livewell Michigan LLC. The tax tribunal held growing cannabis plants was an agricultural use. This conclusion seems self-evident. The bigger question today appears to be regarding the tribunal's jurisdiction to make such a ruling. So I'd like to begin there, and I've heard two questions already, and I'll address both of those as I go, and happy to address any other questions you have. It's important before we begin that this court keep in mind that how you interpret Section 7EE6 today will impact every single farmer in the state of Michigan applying for this exemption, regardless of whether the farmer is growing tomatoes or cherries or corn or cannabis. This is a bigger interpretation than just applying to cannabis farms. And also important to keep in mind that everyone involved here consistently interpreted the language of Section 7EE6 up until when litigation ensued. First, the assessor, when denying the exemption, advised the taxpayer to appear either at the July or December board on the notice. Second, the December board accepted the protest to review the exemption denial and issued a decision. The board's power was never questioned, and I'm using power and authority instead of jurisdiction because I don't think the board of review has jurisdiction. I think they have the power to review something, and then either they review it or they don't. When a December board believes it does not have the authority to review a complaint, they'll reject it. They won't issue a decision. That's how they process it. If in this case, they took the protest, they processed it, they issued a decision. Third, the State Tax Commission is the super assessor of the state of Michigan, responsible for providing legal guidance to over 1,500 assessors. And the commission also published guidance confirming a taxpayer may appeal an ag exemption denial to, quote, the July or December board, period. This is in Appendix B 100163 to Livewell's brief on appeal. The arguments we're hearing here today from appellant were developed in litigation. So after the assessor and the board of review reviewed this, that Section 7 EEC required Livewell to go to the July board. That contradicts the assessor, the board, and the tax commission. But I'd like to focus on the language of that statute that you had asked about, Judge Murray. There's two sentences. I have read these two sentences hundreds of times. This is all I do is property tax litigation and state tax litigation. And I think the key language to me is that in the first sentence, it says it applies to a situation where the exemption is, quote, not on the tax roll. That language is not in the second sentence, and I think that's critically important. Why is it in the first sentence but not in the second? In the first sentence, you have a situation where taxpayer, they're denied the exemption, it's not on the roll as of May. And so what the legislature was providing for is, in that case, it doesn't matter that year, the following year, that the municipality is collecting the tax, right? It's on the roll, they're collecting the tax. So they're basically saying to the taxpayer, you can go to the July or December board this year, you can go next year and come and bring your protest to us. The second sentence doesn't say anything about not being on the tax roll. And so to me, it's implicit that second sentence applies. The exemptions on the tax roll in February or March when the tax roll is set. But then something happens. Maybe it's a new owner and then they have to then refile for the affidavit. That happens May 1st. So the tax roll is set in March, April. They apply May 1st and then it's denied. And so what happens? Well, the exemptions on the roll, that assessor has to go to the July board to get it off the roll. Something changed, some facts or circumstances changed. They don't apply anymore. So he's going to the July board to reverse it, to get that exemption off. And so it's sort of impressing upon the taxpayer in that situation, you need to go to the July board and address this now. And it also has the second, it's a exemption, and so they're not collecting it in July or December. And so it's more imperative to the municipality, we have to get this corrected sooner than later. We can't give you 2 years to get the exemption and then protest it, in December, the end of next year. That to me is the critical difference, and I think the plain language supports that interpretation. And I hope that addresses the questions that you had about the difference in the two sentences.
I mean, for your clients, it was both the case that that the exemption was not on the tax roll.
It was not on the roll.
And it was also the case that an exemption was denied.
Right.
Yeah. So, so why do they get to choose between
the first sentence,
July and December?
The first sentence applies more. So, and I think when you look at how the assessor and the board review and the state tax commission all interpreted this, and they're saying when there's a denial, you can go to the July or December board. It's not on the roll. There's nothing imperative that needs it to be corrected right away. And so that applies to live well, the first sentence. I think the second sentence was intended of the situation. The exemption is on the roll, but something changes. Something changes in May or June, and the assessor is going to go to the July board and try to reverse it. And so they're impressing upon the taxpayer in that situation, which is very limited. That doesn't come up. You have to go to the July board to fix that. But I think to your point as well, the December board accepted the authority to review it, and they did review it and they did act on it. And so when you're talking about jurisdiction and the jurisdiction of the tax tribunal, the Tax Tribunal Act has 13 statutes in it. 6 of them are all about the tax tribunal's jurisdiction. Jurisdiction comes up many, many times within those 13 statutes. And the tax tribunal within the Tax Tribunal Act has the power to review a July or December board review decision that triggers the jurisdiction of the tax tribunal. I think that is the only way to view 7EE and the Tax Tribunal Act holistically and consistently here. I just don't think the legislature intended to tell farmers in this very specific circumstance, you only can go to the July board. It doesn't make sense. It only works if it's on the roll and something is happening right away, and that's in July. We didn't have an opportunity to reply to the reply brief. So there's a couple of things that were brought up in the reply brief that I'd like to address today as well. The appellants argued that the legislature, quote, narrowly limits the time a farmer may appeal an ag exemption denial to 30 days rather than the 35-day period for appealing other types of property tax issues. Livewell appealed to the tax tribunal within 22 days of the board's decision. So their petition was timely, whether you read a 30-day or 35-day time in there. However, appellant does cite this alleged shortened time period as evidence of the legislature's intent to narrowly draft this ag exemption. And that is just simply not true for two reasons. First, legislative history instructs it's not true. Prior to 2007, the deadline for appealing any property tax exemption claim to the tax tribunal was 30 days. The deadline for appealing an assessment notice from the Michigan Department of Treasury was 35 days, and that was all codified under MCL 205735. Well, in 2006, Public Act 174 changed that because there was this discrepancy and it was tripping up taxpayers. And they said 35 days for everything, 35 days for exemptions, assessments coming from property tax or state tax. And so that was promulgated in MCL 205735A, effective in 2007. So when you're looking at MCL 205762A, which still says 30 days, that hasn't been touched by the legislature since 2004. And if you read it carefully, 762A is really about driving principal residence exemption and ag exemptions to the small claims division of the Michigan Tax Tribunal. That's what it's all about. But it does say 30 days for ag exemption and 35 days for principal residence exemption. If you read that with 735A, the principal residence exemptions are brought by the Michigan Department of Treasury. And so pre-2007, it should have been 35 days for that claim, where the ag exemption pre-2007 was 30 days. MCL 205735A and the 35 blanket provision overrides 762A. We're timely filed within 22 days, but I bring that up to respond to their reply argument that the legislature somehow was trying to limit this ag exemption when that's just, it's simply not true. Second, on that point, and this is interesting, obviously I'm very wonky about property tax, but if you again look at the assessment notice issued, the assessor's denial issued, it says you have 35 days to appeal the board action. The Board of Review says you have 35 days to appeal. The State Tax Commission, in that same site I provided a couple minutes ago, says you have 35 days to appeal to the tax tribunal. So with all that said, I ask that you disregard their argument in their reply brief that there's any limitation on the ag exemption process. So the other thing I'd like to address is they brought up the 6ARP case, which is a Michigan Supreme Court decision, obviously, came after the fact. And their reliance is misplaced on 6ARP, but 6ARP is important. It's misplaced because the facts are distinguishable. In 6ARP, if you look at the notice that was received, it wasn't purposefully misleading. So in this case, the tax tribunal had found the assessor's notice was, quote, ineffective and plainly misleading. The notice in 6ARP said you have to go to the Board of Review pursuant to MCL 21130. It didn't provide the time, the date, how you appeal. It just referred to the statute. And the Supreme Court, in reviewing that notice, said this isn't misleading. We don't feel like the tax tribunal had jurisdiction because you missed the board, and it wasn't the fault of the notice that you missed the board. That was the holding of the Supreme Court in 6ARP. This is factually distinguishable because the notice here specifically said you can go to the July or December board. Very, very different. 6ARP, however, provides.
I mean, it also said under MCL 211.7
7EE.
7EE, although interestingly, it miscites that. It says MCL 211.EE. But assuming you can figure that out, then you go to the you could go to the statute. You'd then have to interpret the statute in the correct way, and then you could maybe figure out that it's actually July rather than December that you were supposed to go to.
Yeah, and I think so. You know, a farmer gets this notice and they're denied, and it says, oh, I have to read 211.EE, whatever. So they figure out it's 211.7E. They get there. The first sentence of 7EE6, I think if I were reading it and I wasn't a lawyer, I would say I can go to the July or December board It's not on the roll. I would read it to mean the assessor was right. The notice was right. I can go to the July or December board. I don't know how you read it any other way than how we squarely fall within the first sentence. I do think 6ARP provides a critically important guidance about something that is instructive in this case. The Supreme Court held the border review protest requirement may still be waived by a court. So if your ruling today is, you disagree with me that the plain language of 7EE is that we could go to the July or December board, and you agree with the tax tribunal, you should have went to the July board. The second inquiry is which is what the Supreme Court compels in 6ARP is now let's look at, was there a due process violation? And that's something critically important that we get from that decision. The Supreme Court embraced its responsibility to weigh and consider the facts presented to the tax tribunal, holding due process is a flexible concept and mechanically applying the denial notice requirements is insufficient to review whether due process has been provided. Rather, we must inquire into all the particular facts of the notice provided to praxis because due process negates any concept of inflexible procedures universally applicable to every imaginable situation. So it really impressed upon, I think, this court and the Supreme Court, any court reviewing, that you have to look to see, was there a due process violation? And this court and the Supreme Court are then empowered to cure that due process violation, even if the tax tribunal could not. So even if this court holds the tax tribunal did not have jurisdiction because the taxpayer did not appear before the July board, the Supreme Court instructs in 6ARP that this court can and should cure the due process violation, allowing the taxpayer their day in court. Any perceived error by the tax tribunal regarding jurisdiction is now harmless. You have the power, the judicial power to find there was a due process violation if you don't read 7EE the same way that I do, that allowed them to go to the July or December board. Finally, regarding the ag exemption itself, the property is devoted primarily to growing cannabis plants. There's no dispute about that. Property devoted primarily to agricultural use is exempt. Agricultural use includes the quote, production of plants useful to humans. And I think the state of Michigan legislature answered whether they believe cannabis plants are useful to humans by holding, quote, beneficial uses for marijuana and treating or alleviating the pain, nausea, and other symptoms associated with a variety of debilitating medical conditions, including, for example, cancer, glaucoma, Alzheimer's disease, and many, many other debilitating conditions identified by the Michigan legislature. So I think the legislature answered that clearly on their own about whether or not there's a beneficial use to the cannabis plants being grown.
What about the part about how if it's commercial activity, it doesn't apply?
In what?
Sorry, I thought there was part of the statute that
Yeah, there's like, it breaks it down, and if it's like a commercial activity, they don't mean like, because most crops go for sale, but
I found it.
okay.
MCL 211.7 DD parent D says property used for commercial storage, commercial processing, commercial distribution, commercial marketing, or commercial shipping operations, or other commercial or industrial purposes is not qualified agricultural property.
And that's exactly why the tax tribunal got to 80%, because they looked at how every room within the building was being utilized. And there were some commercial uses, the storage and processing. So in these facilities, what you'd see is a lot of rooms being used specifically just for growing plants. They look like any other field, and that is a purely agricultural activity. And so the tax tribunal treated those as agricultural. But then you go in a room and there's some processing happening. And so, maybe they've harvested it, but then maybe they're separating it out and they're putting into bags or packages. At that point in time, you're no longer farming it, you're no longer harvesting it or growing it, but you're processing it. And so the tax tribunal very carefully, with I think a detailed record, looked at all the rooms and said those are more commercial processing, commercial storage. We're carving those out, and that's how they got to the 80.83%.
So would the same thing happen like with Christmas trees? If, 80% of the property is used for growing the Christmas trees, but then they're, tying them up or whatever in a different part, they would divide it up and give you a partial exemption?
Exactly. Exactly. And sometimes you see greenhouses, sometimes you see a storefront, where there's a greenhouse in the back. And so that would be, they're growing the plants in those greenhouses, but then in the front, there's a storefront. Sometimes that's retail, that's commercial. And so that would be carved out as well. So in conclusion, the tribunal correctly held 80.83% of the property was used for agricultural use. We ask this court to affirm the tax tribunal's opinion. Unless there's any other questions, thank you for your time.
Very much. Rebuttal?
Your Honors, while I was listening to opposing counsel's argument, I think it's important that when you go back to 211.7 or to the statute that says, you have to go to July, or you can go to July or December, that anybody reading that is going to go in and see that in the case of an exemption denied by the assessor in the year the affidavit was filed, you must do this. That's a more specific context. And anyone reading that statute would say, well, was it denied by the assessor? Yes. In the year the affidavit was filed? Yes. Okay. This more specific subsection must control over the more general. Or else what is the point of specifically saying, well, this is what you do when the assessor denies it in that very specific year of application? I think you read that, the more specific must control. And then I also wanted to raise one issue that you raised, Judge Korobkin, was that the commercial as defined in, I believe it's 211.7 DD, is that if you go into the medical and the recreational act, recreational marijuana acts, it does define that as a commercial act. What they're doing, the growing, the harvesting, that's defined as a commercial activity, and we cite that in our brief. And so when you look at it holistically and say, well, is this expressly exempted by the legislature? And then you see that commercial carve out, you see that commercial reference specifically in the acts itself. I don't see how you can come to the conclusion that, well, even with that, the legislature made it express that it should be exempt. Thank you very much, Your Honors. I appreciate your attention to this matter. Thank you.
Thank you very much. Very well argued and briefed. That case will be submitted. We have item number 25, Ali Saad versus Bayan Shaheen, docket number 373538 will be submitted on the briefs. Item number 26, In re Melvin Joseph Lee Richardson III, docket number 372994 will be submitted on the briefs. And item number 27, In re P.A. Ledford Minor, docket number 374891 will be submitted on the briefs. And that concludes our case call for December. Thank you.